If you're watching this in 2026 and you're wondering if it's even possible to immigrate to the US anymore, especially if your country is affected by a travel ban, visa pause, or any other restrictions, you're not alone. A lot of people assume the door is closed. In many cases, it is not. I'm Giselle, an immigration attorney here in Boston, Massachusetts, and I'm the founder of the law offices of Giselle and Rodriguez. And I work with clients nationwide. Today, I want to explain what immigration actually looks like today, who can still move forward, and how to think strategically if your restrictions affect your country. If you find this helpful, make sure to like and subscribe so you never miss a step. Let's start with the most important truths. Even in 2026, USCIS is still accepting initial application filings. Restrictions do not automatically mean you cannot immigrate, adjust status, or help a loved one. In most situations, restrictions affect how a case is processed, not whether it can exist at all. So here are the kinds of immigration restrictions that are in place right now. First, know that not all restrictions are the same. Some countries are subject to broad travel bans that suspend certain visa categories. Others face partial bans that apply only to immigrant visas or specific non-immigrant visas. Some countries experience slowdowns tied to public charge reviews, administrative policy changes, or heightened screening. In many cases, applicants are just required to submit more documentation or undergo additional review. Most of these restrictions affect entry to the U.S. or visa issuance at U.S. embassies and consulates. They do not always prevent someone from filing an application with USCIS. That distinction matters. Here are the immigration cases USCIS still accepts in 2026. Even for applicants from restricted countries, many immigration options remain open depending on personal circumstances. Family-based immigration. Immediate relatives of U.S. citizens, including spouses, parents, and unmarried children under 21, may still file petitions. Many applicants inside the U.S. may still qualify for adjustment of status. Certain waivers may address entry or admissibility concerns. Employment-based immigration. USCIS continues to accept work visa petitions such as the H-1B, L-1, O-1, among others. Employment-based green card options via sponsorship may also still remain available. National interest waivers and extraordinary ability cases continue to move forward, particularly for professionals with strong credentials. Humanitarian and protection-based options. Asylum applications continue to be filed and adjudicated. Withholding of removal and Convention Against Torture forms of relief remain available. VAWA self-petitions, U visas, and T visas continue to provide relief for eligible applicants. Cases that may face delay, but it's not an impossibility. Some cases face delays rather than denials. Applicants may experience longer wait times at embassies or consulates. Additional security screening is common. Some cases require waivers or more strategic preparation. These factors affect timing and procedure, not necessarily eligibility. So should you still apply if your country is restricted? In many cases, yes. USCIS often continues processing these applications even when travel bans are in place or other restrictions exist. Filing now can preserve options that become extremely valuable if policies change. Historically, when restrictions are lifted, USCIS becomes overwhelmed with new filings. Applicants who already filed are far ahead in line. Accepting some uncertainty today can help you avoid major delays tomorrow. Why uncertainty is normal in U.S. immigration. U.S. immigration policies change constantly. Rules are modified by new administrations. Policies are challenged and overturned in court. Agency interpretations shift over time. Entire programs are sometimes rescinded or replaced. The immigrants who most likely succeed are not the ones who waited for perfect clarity. They are the ones who acted strategically while certainty existed. Why legal guidance matters most for restricted countries. When restrictions exist, immigration becomes more technical, not impossible. An experienced immigration attorney can determine which restrictions actually apply to you, identify exemptions, waivers, or alternative strategies. We will also advise whether filing now makes sense or whether waiting is smarter. Most importantly, legal guidance helps you avoid decisions based on fear or misinformation. Immigration restrictions do not apply equally to all countries. Some countries face broad suspensions with limited exceptions. Others face targeted restrictions affecting only certain visa categories. Some are under the public charge related review that increases documentation requirements and further scrutiny. In many cases, USCIS may still process petitions even when consular visa issuance is paused. Because these rules change frequently and apply differently depending on your fact, general online information should never be your only source of guide. Being from a restricted country does not automatically close the door to immigrate into the United States. Many people still qualify through family, employment, or humanitarian pathways, especially those already inside the US. The real risk is assuming you have no options before understanding what is still possible. If your country is affected by a travel ban, a pause, or a restriction, reach out. I will help you understand what options, if any, are still available to you, whether filing now makes strategic sense, and how to move forward with clarity instead of guesswork. You do not have to navigate this process alone.